Yeah, please, your lordship. I'm praying for listing of a revision petition, lordship, that is filed lordship on yesterday. Well, some urgency is there because lordship, the petitioner's company has been attached by lordship order of the line at MST lordship. Yes,
When do you want? When?
Monday lordship. No, lordship. Because the office
Already
is
a lot of cases have been fixed. Immediately after reopening.
lordship. My only problem is that lordship, our is a public office lordship. That office has been lordship completely attached by the lordship. Civil Nazir of Tinsukia lordship. So that is the problem, lordship. Otherwise, lordship, I would have put lordship opening. No, Monday, if possible, some interference is necessary, lordship, because we have preferred an appeal against the award of the tribunal. That case is still pending, lordship, and during pendency of this case, lordship, the process has been initiated, lordship, execution process. And now, lordship, office is completely, lordship, attached by the civil Nazir.
What is the decretal amount?
It was, lordship, 15 lakhs, lordship. 15
lakh.
lakhs, some thousand, lordship.
Why don't you pay the amount?
Because we have preferred that order was judgment of completely illegal, lordship, without with any basis, lordship, that order was passed. So we
Even
have challenged
for saying that order, you have to deposit the security here.
lordship, that much lordship will consider Monday, lordship.
Pardon?
On Monday, lordship will consider, if lordship direct to deposit some amount, lordship, we will do that, lordship.
But unless you deposit the amount, there shall not be any stay.
Lordship, on Monday, lordship, I will instruct with my lordship client also.
What?
Monday,
What?
Monday. Obliged.
As regards item number 2, your lordship, I have some minor typographical error in the petition.
Item
Maybe
number 2.
2, yes. Maybe I'll have to
Today's
correct the
case.
same. Yes, yes. Some
Yes,
dates.
Mr. Sutter.
My lord, I am there. Let him rectify his mistakes and come up for admission, my lord. Because it is a concurrent finding of fact, landlord-tenant relations. He has
Okay.
been declared as rank defaulter.
Okay. Then after BO.
Yes, my lord.
Okay. Mr. Your good name?
AM Doctor
PM Dr. Learned Counsel. Order.
for the petitioner,
Petitioner.
your lordship.
With consent from the other side, press for listing the matter after vacation. Fair allowed.
And your lordship, meanwhile, I filed one I also for stay of the judgment. That can be done, your lordship.
No, when he is to rectify
No,
the
unless
mistakes.
the
Yes.
petition is admitted, how can we pass the
Yes.
stay order?
Otherwise, your lordship, some mistake with
You
regards-
first make necessary correction, thereafter we will consider. Not now.
Obliged. Obliged.
May I please, your lordship?
Yes.
I beg to mention for listing of 2 RSM matter after being vacations, your lordship, any date may be fixed.
Take a date permit.
For motion item 1,
May it please, your lordship. And this transformation is filed under section 24, lordship, CPC, for withdrawal of a money sum from civil judge, Criminal Division number 2, Aizawl district, lordship, Mizoram.
Mr. Pupon, the dispute between the two communities are in the Manipur, not in the Mizoram.
But my lord, the Mizoram is also affected because my lord,
How?
Mizo,
How Mizoram is affected?
Mizo organization has also lordship demanded lordship to throw back the Meitei community from the Mizo districts, lordship.
Pardon?
From the Mizoram, lordship.
Hmm.
They have also they demanded that Meitei community should not be stayed in the Mizoram, lordship. And Lord, even my lord, I have categorically mentioned, lordship, that one football match which was organized by All India Football Federation has also been lordship declared abandoned because of the Manipur Football Academy has denied to go there and to play the football matches. And they have demanded for a neutral venue, lordship. And I could not annex, but my lord, here is also a news article published, lordship.
Pardon?
A news article I could not annex in the main petition.
No, not necessary news article on how
Well, it
news
is
article
regarding
will
lordship.
help you.
And my lord, there is also threatening part, lordship. I have categorically stated in paragraph, lordship, 15.
When and how you have been threatened?
It is that they had written the petition number through on WhatsApp, Lordship. The respondent said Puya is waiting for you, Lordship. And that Puya is a person who has once threatened to kill the petitioner, Lordship. Petitioner number 1 hearing, Lordship. And another aspect is the distance, because my lord, two lady petitioner also dragged into the into this case, Lordship.
Maybe, but the respondent also contest the suit here in Guwahati in the event of
Because
the
petitioners are
case
not,
being transferred.
not the local residents of Guwahati, Lordship. They are
Pardon?
staying, the petitioners are not local residents of Guwahati, Lordship. They are staying temporarily here, Lordship. And my lord, any neutral venue, Lordship.
Okay, let notice go at this stay.
Lordship, and my lord, I am praying for stay because
No, stay. Let the other side come. We'll hear only thereafter we'll consider the stay.
Lordship. And so then an observation may be given then, Lordship.
Pardon?
Then an observation may be given, Lordship.
Heard, Mr. Heard, learned for the petitioner. This petition under section 24 of the Code of Civil Procedure is prepared by the petitioner for transferring of manuscript number 288 of 2024 pending before the Court of Learned Civil, the Senior Division number 2, Faisal, Mizoram.
Lordship.
2. Any of the court, civil court under the jurisdiction of learned district as Kamrup and Guwahati, or to any other nearby district, civil court. Mr. Pokon, learned counsel for the petitioner submits that the petitioners are the respondents in the title or in the manuscript number 288 of 2024 pending before the Court of Learned Civil Judge, Senior Division number 2, Aizawl. And the petitioners are hailing from Manipur and they belong to Meitei community. And the respondent herein who had instituted the manishut in the Court of Learned Civil Judge, Senior Division number 2 is belonging to the Zoo community, belonging to Kuki Zoo community, and the petitioner herein have received threatening from the aforementioned respondent, and as such, there is a requirement for transferring of the aforementioned proceeding to any of the civil court in Guwahati or nearby district. The submission of Mr. Pokon, learned counsel for the petitioner, needs further consideration at this stage. Not notice be issued to the respondent, returnable in 4 weeks, that be taken by the third court with 80, and also by usual process within a week from today. Interim pair of the petitioner will be considered on appeal for the other side.
Lordship. Obliged.
Item 3,
May I please, Your Lordship? My lord, here in this case, the petitioner is the plaintiff in the suit. The suit was filed for declaration of right title interest and cancellation of sale deed. My lord, the said case was proceeded ex parte, and the ex parte judgment was passed dismissing the suit. Against that matter, the appeal was preferred in the lower appellate court. In the said appeal, a petition for amendment of the plaint was filed. And the learned lower appellate court rejected that prayer. I have annexed in page 44.
But where is that sale date? Is it a part of the record?
A sale deed, my lord, I have not annexed because I have challenging the impugned order at page 44.
No, that's
Parties
okay,
are
but there is an observation of the trial court that in the form of sale date number so and so, The petitioner want to introduce evidence in guise of amendment of pleading, which is not permissible in the light of provision.
My lord, my submission before your lordship is this. The amendment of the plaint can be filed in the appellate stage. And even in the second appeal also, the amendment for plaint is filed. There is a Supreme Court decision, my lord. Therefore, the learned lower appellate court are in law in dismissing my petition without going to the merit of my petition. Because the learned lower appellate court held this Order 6, Rule 17, Order 41, Rule 27, all these are applicable. Because the plaintiff has a right to amend the plaint in the appellate court. And that point was not considered by the lower appellate court. And this impugned order is not a speaking order. I can show your lordship this judgment. Page number 3, bottom. Appeal being the continuance of the original proceeding, and the appellate court having the power to exercise all the powers vested to the trial court, would necessarily have the power to examine the application filed under Order 6, Rule 17, and it cannot be said that such power of the application for amendment by the appellate court would not be available on the ground of Rule 17, Order 6, curtailing such power when the fact does not, for the reason already indicated therein above. And appeal being the proceeding of the continuance of the original suit, it can safely be concluded that the first appellate court is vested with a similar power proceeded by 2 of Section 107 is clear, unambiguous and explicit. The same would be, and the same power shall perform as nearly as possible be same the duties conferred and imposed by the Code of Courts and the original jurisdiction in respect of the institution. Therefore,
No, that's all right. This is not the observation of Supreme Court. This is the quotation from a decision of High Court of Andhra
Yes.
Pradesh.
Where
Where is the finding of Supreme Court?
paragraph number 23 at page 12.
Yes.
It is well settled that the rules and procedure are inserted to be helmet of the administration of justice. A party cannot be refused just relief merely because some mistakes, negligence, inadvertence, or even infraction of rules or procedure. The court always give a relief to amend the pleading up to the parties unless it is satisfied that the party applying the acting is a malafide on the part of the plunder. He had caused the injury of the opponent and cannot be compensated by the order as the cost.
But going by the order of the trial court, not the appellate court, can it be said that the appellate court has held that it has no power under the sixth section? That is not the finding of the appellate court. The finding of the appellate court is that the appellant petitioner want to introduce evidence in the form of service number so and so.
My lord, your lordship, then I come to next page, my lord, page number 13. Page number 13, 5. There is no impediment or bar against the appellate court permitted the amendment of the pleading so as to enable to party the
Paragraph number?
5 on the top, page 13.
Of your
No, of this judgment.
decision. Paragraph number?
Paragraph number 5. 5 means small 5 on the top. 4, then 5. Paragraph number 1, 3. Page number 1, 3.
1.
1, 3. Yeah, 13.
Yes.
Small 5 you also can see. There is no impediment or bar against an appellate court permitting the amendment of pleading so as to enable a party to raise a new plea. In all that is necessary is that the appellate court should observe a well-settled principle subject to which the amendment of pleading are usually granted. Naturally, one of the circumstances which will take into consideration that the amendment is granted is delay in making the application seeking the amendment. And if the appellate states the reason why it was not sought to be trial court, if the necessary materials on which the plea arises for the amendment of the plea may be decided already there, the amendment may be more readily granted. Otherwise, but there is no prohibition against the appellate court permitting the amendment at the appellate stage merely because the necessary materials is already before this court. So new plea can also be taken, my lord. There is a
Let notice go at this instead. And in the meantime, you produce the cell deed also by filing an additional affidavit. And you are also to satisfy the due diligence, the proviso to Rule 17. Part of Mr. S.C. Sharma, learned senior counsel, assisted by Mr. T. Burtas. Correctness or otherwise of the order dated 3/1/2025 passed by the learned Civil Judge Senior Division Dhuri in Mizje case number 77 of 2023, arising out of title appeal number 1 of 2022. Is challenged in this petition under Article 227 of the Constitution. Is to be noted here that by impugn order dated so and so, the learned Civil Judge Senior Division Dhuri has dismissed the petition number 752 of 2023 filed by the petitioner herein before the learned Civil Judge Junior Division Dhuri for amendment of the plaint. On the ground that the appellant struck petitioner want to introduce evidence within bracket in the form of cell date number 4246 struck 1973 bracket closed in guise of amendment of pleadings, which is not permissible in the light of the provision of the law as laid down under Order 6, Rule 17 CPC. Read Order 6, Rule 2 of CPC. Read Order 41, Rule 27 CPC. Sir Sharma, learned counsel for the petitioner, submits that the impugned order is illegal and arbitrary, and the learned arbitrary and cryptic also, and the learned Civil Judge Senior Division has failed to take into account that in appellate stage also the plaint can be amended. By The submission of Mr. Sharma needs further consideration at this stage. Notice be issued to the respondent later than delay. For weeks, step be taken by registered post with AD and also by usual process to any of it to them. List the matter after 4 weeks. In the meantime, Mr. Sharma shall produce bring on record the cell date number 4246 of 1973 by filing an affidavit before next date. Placed according.
Further proceeding may be stayed. Next date is fixed on 9/4/25.
9/4.
And the further proceeding of the appeal may be stayed.
Okay. Mr. Sharma further submits that the next date is fixed before the learned
Lower appellate
civil
court,
senior division on 9th of
9/4/20.
and as such, till disposal of this petition, the further proceeding may be stayed. The taking note of the submission of Mr. Sharma, learned counsel for the petitioner, further proceeding of NIJ case number
Title appeal number
so arising out of title appeal number
1/2022.
stands state till returnable date.
Item 4,
May I please your lordship, kindly pass over the matter for the time being. My stay is on legs another floor.
We don't have mass matter.
item 5, item 5,
Now the case for the petitioner on call, rest shall list the matter after due vacation.
item 6,
May I please, your lordship?
Yeah.
Well, in this appeal matter, I have very recently engaged. May I pray that it may be taken up on next Tuesday.
Mr. This is sort of learned senior counseling assisted by Mr. D. Burdock, learned public court of petitioner, price for listing the matter of next Tuesday. Fair.
item 16,
Lordship, yesterday's query was whether the refreshing the case yesterday, Lordship, where the learned senior argued, and Lordship had made a specific query whether the learned court below had discussed about being a parenthesis case.
Yes.
Lordship may come to page number 95 for a moment.
Page for
95. The topmost portion talks about heard the learned counsels on both sides and perused the records along with documents and judgments
But,
cited by the petitioner.
uh,
This I had shown, Lord.
Mr. Das, the other side is absent.
They had already argued that matter. It was only me who.
Even then,
They were there.
yeah, after some time.
admission, item 7,
Right, please, your lordship, kindly pass over for a time being. Senior is on legs.
Time being,
item 8,
May I please, your lordship? I have received a copy of the objection filed by the respondent today itself. Opposition, they filed an opposition and I have received a copy today itself. So I may file a rejoinder if necessary. Time may be granted.
This I is for what purpose?
Delay, condemnation of delay,
Contradiction of-
129 days.
Okay. Mr. Yogo.
MR Sodial.
MR Sotiel, learned counsel for the petitioner, submits that he has received the objection
Yes, opposition.
filed by the opposite party, and he may be granted some time to file a rejoinder. There is accordingly allowed. This is the matter.
My lord, here PP is also shown as my lord, response number 1, my lord. But perhaps 125 proceeding, my lord, there, but they made party PP state of as response number 1, my lord. In the cause list also, PP also shown, my lord. That's why,
Okay, on next letter, we'll see.
my lord. Obliged.
Deeply obliged.
Item 16.
Yes,
Yes, Lordship.
page number 95.
Page number 95. Lordship, the first order of the first appellate court starts from 85. From 85 to 94, he has discussed what both the sides have placed their cases in. He has discussed in totality. On page 95, he starts his own discussion. Page 95. Heard the learned counsels on both sides and perused the records along with the document and judgments cited by the petitioners. I have also carefully gone through the entire records of the main case. So this shows he has taken into consideration both the parties' contention as well as the record. Now, Lordship, this has been read yesterday regarding what are the various things. This has been read. Not reading it again. Lordship had made a specific query whether the prima facie case was, whether he had come to the finding that there is a prima facie case or not. Lordship may come to page number 102.
Yes,
Lordship, what they had said is that they do not have a prima facie case on account of they do not having a registration certificate. And they are not, they were not authorized by anyone, or there is nothing in the constitution regarding who can file a case or whatever. That was their case. So what if Lordship takes from below 1, 2, 3, 4, 5, 6, 7, 8 line from below? It starts with herein. May I read, Lordship?
yes.
Herein it can be seen that the plaintiff's petitioners has made out a case. Now that the word prima facie is not there, I ask myself the question whether the word prima facie has to be. It says it has made out a case in favor of going into trial, and apparently the balance of convenience does lie in favor of the plaintiff. What he has, this statement has to be read.
Mr. Das, you tell me
Yes.
whether prima facie case for going into trial and prima facie case for granting temporary or ad interim injunction is same thing.
Lordship, in my respectful submission, when there is a prima facie, the concept of a prima facie case, whether going for a trial or a temporary injunction has to be same, because in my respectful submission, because of the fact that as per their argument, the case of the plaintiff has to stand on its own legs. That's the basic idea of a prima facie case. Now, whether they were, now let us assume for a moment, a devotee comes of the Bhattadua Than and says that no, this is wrong, this ad hoc committee is wrong, then he would not have a legs to stand because he is a devotee. Whether he has a right to sue under the society's name, those things would have come. Then he would not have made a prima facie case. in my respectful submission, Lordship, the plaintiff has made it a prima facie case by virtue of how they being in the committee. Now, why they have filed this case regarding our case is that there is no provision in the Constitution for formation of an ad hoc committee. If there was any irregularity, anything, then there is a provision in the Constitution under clause of the Constitution, which clearly mandates that there will be 200 members who will be giving and writing to the Porisalana Committee. They will to look into it, and then there will be a thing. Now, what has happened? The learned court below, both the courts, not just the first court of the first instance, as well as the appellate court also, have come to the correct finding as to the fact that at the time of filing of the suit, the Porisalana Committee was in existence because they were elected in a general body thing, in a general body session. So when they were elected, now they have said, they have not made the ad hoc committee a party, which my learned senior had raised the contention. When the ad hoc committee is not a legal, where there is no question of forming any ad hoc committee, that's why no ad hoc committee was made a party, because that is not a legal entity as per the plaintiff. There is no way. What we have sought in the injunction prayer. In the injunction, we have asked for these people not from restraining from interfering with her works. What they were doing is that they were interfering with her work. Since they were interfering with the Porisalana Committee, this was the reason that we had asked for a temporary injunction. Now, regarding if your Lordship allows me to place also, a thing has been argued that we will be ciphering off with the funds, or we'll be doing everything that we are doing as per the Porisalana Committee. That has been documented, that will be audited, because there will be, why audition? It has to be audited because when tomorrow, once there will be a renewal, there has to be an audited report. No renewal can be done. And regarding the renewal part, I just like to show, Lordship, the renewal registration. Yesterday, the date was told. Yesterday, the date was 17/3. Yesterday, it was. Yesterday, it was told that our renewal was invalid. Then on 17/3. Now, this renewal certificate may be perused. Lordship, it's in the middle. Valid up to 17/3/23. Validity extended up to 24/10/27. Now, Lordship, what I submit is that with this renewal certificate,
Yes.
Lordship, the court of the first instance had rightfully to come to a finding as to the validity of whether it is a valid registered society or not. That has to be given by the societies, the register of the societies. Lordship, for a moment, page 101 may be perused. 101. Lordship, second paragraph, therefore, Lordship has got. I just read to it. Therefore, the state government has prescribed the period of validity of registration and has incorporated provision for renewal of registration, and the effect of failure to renew registration is also provided. Therefore, if the requirement of law has not been complied with, the Registrar of Firms and Societies has been vested with the power to pass appropriate orders as provided under the Societies Registration Act 1860 as amended by Assam Amendment Act. Lordship, I submit, Lordship, if this registration certificate, which says from 17/3 to 24/10/27, from 23 to 27, If this registration certificate was not in existence, then maybe the whole society would not be in existence. The contention raised by learned senior regarding the part that they are not a registered society, so they cannot sue, this contention falls flat in my respectful submission, because as of now, there is nothing on record which the respondents, which the appellant can show that this registration certificate has been cancelled. As of now, this registration certificate holds the field. So he has rightfully said regarding the registration part, it is not the court who can decide as to whether it's a valid registration or not. It is the register of society which will say as to it's a valid registered society or not a valid registered society. Why? Because under the Societies Registration Act, there are various stipulations out there. You have to give audited reports. There has to be signatures from the ADC. So these are various stipulations. A court cannot come to the finding whether a society is validly constituted or not, or whether the renewal is validly. Because for renewal also, in my respectful submission, there has to be.
So yesterday I was asking you about the prima facie case and the irreparable loss.
Irreparable loss has been discussed. Lordship, here irreparable loss he has discussed in page 95, third paragraph. I have showed that he has talked about the irreparable loss. Now, what is the irreparable loss, Lordship? Granting of injunction is equitable relief.
Now, is there any finding to that effect?
Lordship, here, I will submit, Lordship. In the appellate order, it can be seen where the appellate order, if Lordship allows me to take the appellate order, what the appellate order has taken.
No, you first answer.
Yes, Lordship. I just want to bring a synergy between the two. What had happened is that he has here, when he started, he talks about the prima facie case, which I have, Lordship, in my respectful submission, I have submitted that when he has said that he has made out a case, that's the prima facie case that he is talking about. Balance of convenience.
This prima facie case, according to the learned trial court, is to go into the trial.
No,
This
Lordship,
observation is not in relation to granting of this temporary injunction.
no, Lordship, it has to be, this line cannot be segregated or severed from the thing. This has to be understood what has been discussed in the earlier paragraph. What business did a learned trial court would have to discuss about the validity of a registration? They are saying it's not a prima facie case. Their contention was that it was not a prima facie case because they did not have a valid registration. So he has discussed about what is a valid registration. So when he had discussed about the valid registration, then in my respectful submission would be, Lordship, it will be in my respectful submission would be, that means he had tried to understand whether there was a prima facie case, because if there was no valid registration, he had gone into the question, he has applied his judicial mind to understand whether he can, whether or not.
Where, in which part of this order the trial court has reflected it?
Lordship, this has to be in my respectful submission, if I have to understand, since I cannot go to his mind, if I have to understand from the order, here, when he starts from 95, he says, further it is the contention of the opposite party. Page 97 he starts with the contentions of the opposite party. He starts with the contention, Lordship has got it, further it's the contention of the. So when he says, he has taken into the contention, he says that the President of the Khan Provisional Committee was not authorized by the general members to file a suit or defend a suit. It is the further contention of the opposite party that the society is being governed by the Societies Registration Act and that the bylaw of the Khan has not mentioned as to who can sue, and in absence of any stipulated thereof in bylaw, section 6 of the Society Registration Act shall apply. It is stated that the petitioners have filed the instance suit beyond their authority, and as such the act is ultra virus. It is further stated the petitioner has no locus standi to file the instance suit as Societies Registration Act in section has clearly stated that a society shall be ceased to be a registered society in effect from the actual date of expiration of its original registration. So, sum and substance, what he has said, when he had went to the contention of it, when he discussed about the, when he discussed the validity of a registration, when he discussed section 3B, C, D has been inserted. These are the new insertion. This insert. Earlier, what had happened, Lordship, in the Society Registration Act in 2019, there was the amendment wherein it was said that once it is the registration goes, then if the effect also goes. Now with the new amendment, it is not there. So this is what, in my respectful submission, Lordship, he had understood, he has taken into account regarding the prima facie case, regarding the validity of the registration. Once he said it's the state government who has to do it. Regarding the irreparable loss and injury, he has talked about it. There is also a scale which shows that the opposite party by default in page 102, last part, Lordship. If I'm reading that part only, there is also a scale which shows that the opposite party by dissolving the duly elected committee of Sri Bhattacharya Than before the expiry of its tenure has violated the constitution of Sri Bhattacharya Than and has accordingly harmed the reputation of Bhattacharya Than. So keeping in mind the circumstances involved in the case and in view of the discussion made above, and also to avoid diverse and prolonged litigation, the opposite parties and their men are restrained from interfering in the daily works as performing the duties of Bhattacharya Committee till the disposal of the suit. Now, Lordship, your contention was also raised that still the disposal of the suit. I had taken a specific instruction to that effect, that it is your term ends on May 2015. 15 May 2025, the term ends. I had asked the specific question that the order is still disposal of the suit. So what do you intend to do? Then they had said that it's a clear instruction from my client saying that they will ask a permission from the court for holding a general body for election of a new Parisalana Committee. Because this ad hoc, now Lordship has to understand what is the crux of the matter. The crux of the matter was that we were the Parisalana Committee. We were duly elected in May 2022. Our term ends on May 2025, where on 9/6/24, there was some kind of an unrest, some kind of a thing. Whatever is the thing, there will be a matter of trial. Now, even if we take 9/6/24 was the Parisalana Committee for 6 months. That 6 months also has elapsed. From 9/6/24 till date, it has also elapsed. Thereafter, Your Lordship, one has to also understand is that Parisalana Committee was only, as per them, it was only regarding the irregularities of the thing. What about the daily thing? Daily thing is the Parisalana Committee. Now the learned court below, the trial of the first instance, as well as the appellate court, has come to the finding, has taken into consideration every discussion that we had made, every contention of both the parties, and have come to the specific finding. Now Your Lordship here has to come to the fact, if Lordship comes to page 135 for a moment, Lordship. Now the appellate court, 135, Lordship. The judgment has not brought the judgment. This is the judgment which is quoted in the judgment of the appellate court itself. Now, Lordship, this judgment has not been read in toto. What it says, if Lordship, shall I read the whole judgment? It's the Honorable High Court in the case of Radhavari, such and such, while taking into consideration and discussing the judgment passed by the Honorable Supreme Court, Wonder Limited versus Antox India Private Limited, reported in such and such, has observed the following. Thus, an appeal against the exercise of discretionary jurisdiction is really an appeal in principle. And that is why, unlike a regular appeal in ordinary sense, where whole evidence on record is examined anew by the appellate court, which is really examined in an appeal against the exercise of discretionary jurisdiction, is the legality and the validity of the order. And it can be set aside and should be set aside only when there is patent error on the face of the record or order in against which they establish or settle principles. If two views are possible and a view which is reasonable and logical has been adopted by the trial court, the other view, howsoever appealing, would not be allowed to be substituted in place of the trials court view, which are otherwise reasonable and logical. I ask myself, Lordship, this question is, so the trial court came to a finding where he said that the functioning of the Parisalana Committee there was no hindrance in the functioning of the Than. The Parisalana Committee was doing their work. There were some questions of now they have talked about filing an FIR regarding forceful, or they have also not filed an FIR against the financial irregularities against us. They have also, there is nothing on, now question is that some people comes and says that no, there is some financial irregularities. This is done, that is done. If everyone's word is to be accepted, then a society will not be run in that way. Now they have come, they have some, now why we had to come to file a title suit is that we had adopted a legal procedure so that they do not restrain, because they have been restraining in our work, so they did not restrain in our work. So we came for an injunction, which was rightfully granted by the trial court. The appellate court, in a reasoned order, the appellate court also has not just passed an order saying that, okay, I find that there is no irregularity in the order of the trial court, because Lordship has to look into it. Again, this has been read, the appellate court's order has been read and twisted in the way suiting the appellant. Lordship, why I'm trying to say is, Lordship may come to page number 128 for a moment. This paragraph was read.
Yes.
Discussions, decisions, and thereof. Now, turning to the facts, I have gone through the impugned order dated 23/9/24. While passing the order, the learned civil judge Nagaon has considered all the three basic ingredients for consideration of the petition for temporary injunction, that is prima facie case, balance of convenience, and irreparable loss and injury, by taking into consideration facts on records and considered the nature of dispute as well as circumstances involved, and held that the principle of balance of convenience and irreparable loss and injury were in favor of the petitioners, and hence allowed the prayer of temporary injunction and petitioner, plaintiff, and restrain the appellants of peace till the disposal of title suit such and such. So on this count, there is no perversity as per the consideration of the three principles are concerned. Pausing here, what is the line saying? It's saying the appellate court first. What the appellate court did by this line, which can be understood and deciphered, is that the appellate court first came to the finding whether these three principles were discussed or not. The appellate court came to the finding, yes, these three principles were discussed. It was discussed. Now the second line is important. Now whether the learned court was just in conclusion and had come to a correct finding, I am discussing the same in ensuing paragraph. So the first gate is crossed.
Whether the appellate court has discussed the prima facie case.
Yes, Lordship. If I may allowed to read the judgment, she has discussed everything.
Where? So us.
Lordship, then I'll read the judgment from 129, because
So the specific part where the appellate court has discussed the matter.
page 133. It's in paragraph, it starts from thus, Lordship. It'll be paragraph 1, the last, before the last paragraph, line would be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line from below. The last paragraph, the 10, thus both prima facie case and the balance of convenience under the circumstances are in favor of the respondent. Lordship has got it. And below, the learned trial court also considered principle of irreparable loss and injury based on the facts pleaded. I have considered the same, and from the pleadings of both sides, and there is not much doubt that the petitioners' respondents were a functional committee about the work of Than till the meeting of 9/6/24. And all religious and other activities of the Than were continuing properly without any hiccups. The allegations raised by the OPs in regard to the charges of corruption can be determined only after due inquiry by appropriate authorities. What is wrong in this line? Can the allegations, counter allegations be determined just by it? Now she has discussed both. She has discussed both the prima facie case, balance of convenience, and the irreparable loss and injury. When both the courts have discussed all the three cardinal principles of an injunction order, based on this, again, the judgment says it's a discretionary order. This cannot be looked into the fact, it cannot be looked into the viewpoint of a appeal in a normal appeal where evidence is to take it. Prima facie, what is it? There is no dispute of the fact that then till 9/6/24, when this committee was alleged committee was formed, it's the Parishalana committee was functioning as such. We are still functioning, but they were creating a hurdle. That's why we filed this case. Now, when that committee is a duly elected committee, I respectfully submit, Lordship, that the injunction order does not suffer from any illegality. It is a perfect legal order and it may not be interfered.
Yes.
And Lordship, I just because Lalit Sine had also made some points. Lordship, regarding other points regarding whether the suit is
No,
defective.
we are not finally deciding the matter.
Today.
You want to decide?
No,
decide the
Lordship,
matter
I want to
today?
file an object. Yesterday only I had said I wanted to file as per the instruction because whatever, and all the materials are not there. The documents which are filed with the title suit, that is not before the court. So notice may be issued as of now, records may be called for. I pray that the interim order, again, Lordship, the interim order they are seeking. Lordship, page 20. In the interim, Lordship, in the interim, considering the facts and circumstances, the respondents here may not be permitted to continue with the management of Sri Bhattacharya Khan till disposal of the suit, and an alternative arrangement may be made by the Honorable Court to preserve the sanctity and serenity of the pious religious institution and in the best interest of it. Now, Lordship, we had filed the injunction petition for restraining the opposite party. Now they are seeking for an interim order where they are saying that we may not be permitted. We may not be permitted. So whether this interim order can be granted by this honorable court in this petition that's up to the Lordship the thing. Because here, if we are running it, whether they are properly elected body, which is running this Khan, can be replaced. And this term is over. This term is getting over on 15 May 25. And as I had already submitted, where the specific instruction has been given saying that in 15 May 25, once the term is over, they will ask for a permission from the court for holding of a general body meeting, and then the new committee will come. Probably when the new committee comes, this whole title should maybe infectious also. That's what I feel. That's a different thing altogether. But as of now, since we are running this thing, and still there is no complaint from any devotee saying that the Khan is not being run properly or something. And we are submitting everything.
Okay. Yes.
My lord, I have already dealt with those issues. I need not have to elaborate it again. I have already submitted regarding these three golden principles. What are the discussions made? Lordship has already gone it. I'll just reply to 3 points here. My learned friend is trying to make out the case on the same line that both the courts below were swayed away by the fact that this is an elected body, elected. So it is untouchable. Nothing can happen. That approach is wrong. That approach itself is wrong. Lordship has seen the trial court. It went on as if this election of that committee has been put to challenge. That was the approach made. That was not correct. They may have a right. Other issues may be dealt with in the trial, but so far granting of that equitable order, the court will have to definitely look into these aspects, specifically the prima facie case for issuance of an injunction regarding the the one of the points regarding their the registration. Fact remains that on the date of filing of the case, on the date of issuance of the injunction order, on the date of making the injunction order absolute, there was no extension. There was nothing. It was over. It was long back ceased to be registered. So what would be the effect if it is ultimately registered? I mean, the renewed, that will be decided in the trial. That is cannot be a ground that no, they have subsequently extended. They have placed this certificate today. I have seen it. It was issued on 25/10/2024. The certificate is dated 25/10/2024. It says that means on 25/10/2024, it was extended. It was extended, renewed, valid up to 17/3/2023. It was valid earlier, and then this expired. Thereafter, the case was filed, order was passed, then it was extended only on 15/10/2024.
On the date of granting injunction, there was no resistance.
No, nothing. It was on 25/10/2024. Left-hand column, Lordship has seen. This injunction was granted on 23/9. This order appears
Yes, 23.
23/9. 23/9/2024. 23/9/2024. This was extended, issued on 25/10/2024. So what would be the effect? That would be taken care of in the suit. That is another issue. But prima facie on that day, this was not a registered organization. And as I have submitted, there are only 2 persons in the name of that organization. It cannot bring a suit. That would be a ground to be taken into account. And the maintainability of the suit on the prima facie, what is the right they have, right to sue, those were not at all discussed, nothing. Now, point has been new point. Those points I have already addressed, probably Lordship has taken note of yesterday. And my lord, having read thoroughly the judgment of the learned trial court, as I submitted, I found that the court has taken a turn or taken an approach which is totally away from the main question, the main object. And the learned appellate court, in turn, without going into all these things, how the court has considered things, took it as if all these required principles have been discussed, materials have been analyzed, and then given a decision. Lordship has seen there was nothing. There was no discussion regarding prima facie case, balance of convenience, irreparable wrong. But yes, said all 3 are there. That is not enough. That is not enough. And regarding my term, argument has now been advanced that the ad hoc committee's term has already expired. I respectfully submit that this concept is wrong. I could not even take over. They approached the court, got an order. The ad hoc committee constituted, ad hoc committee issued a letter to them, they kindly hand over the search. They approached the court, got an order, and continuing. So how come our term will come into it? We could not enter into. Our term did not start at all. Our term will start only when we take over charge. Then mandate is, general body's mandate is within 6 months you complete the things, hold the general meeting, elect a new body. That is the command on us. That is the command on us. We could not do it because we could not take over. They are holding back all the papers, everything. When we ask them to hand over charge, they approach. This is the case. As I read out yesterday, Lordship has seen in their plane. They said they gave a notice to us asking the charge, so we approached. That's the cause of action arose for them. Therefore, it is not that term has been over and the ad hoc committee cannot come into force. No, it should be allowed to come into force. The court's order has blocked us. We could not. And that is why we are litigating. We have to follow the mandate of the general body. General body is the highest authority. Whether the general body decision was right, wrong, that would be gone into in the suit. As I said yesterday, a committee having been dissolved already by an appropriate authority, the general body, can it be revived by whoever injunction in the interim? They say that we have been dissolved, another committee has been formed. They indirectly ask that the committee, the decision of the general body dissolving us should be declared as illegal and we should be allowed to continue. Once this prayer is allowed, then only they will come to the fore. Otherwise, their existence is not there as on today, but they are working on the strength of the order of the Honorable Court. Therefore, my full submission is the Therefore, my respectful submission is that the orders are required to be interfered. And Lordship will pass an appropriate order that injunction so granted and so affirmed by the trial court should be put at naught for the time being, no further effect on that. That is in my respectful submission is required on the day.
Can we do this way?
Yes.
We keep the matter further, let him file objection.
Yes.
We'll finally dispose of the matter.
Lordship, I think after arguing so much, there remains nothing further to argue for me at
No,
least.
therefore, we can finally take a call upon
Lordship may
this.
finally decide this.
No, but he want to file objection. If
What
we-
objection
Because
he will file because he has already argued those points and he has his objections, everything, those are recorded there only. He
the
cannot improve the
records-
case either way.
No, he cannot.
I cannot
He
improve the
improves,
case.
he cannot. On your record. That is what I am saying. This filing of objection at this stage is a misnomer really.
And
I feel so.
and
I
the-
feel so.
and
There is
the
nothing. We cannot
point
improve.
that the argument that
Whether our contentions are based on records, whether the points we have urged, both sides, can be sustained or reasonable on the fact
and for that the
law laid down under
records
the
needs to
records.
be there. For
The-
that a written statement.
Those are there
documents-
already. I have placed.
No, the documents are not there.
Already I
For
have
those
placed.
and
Further
moreover,
documents are not
a
necessary.
point has
But
been
those
said-
not decided, not discussed, not taken into account.
no, it is
Why
taken.
this honorable court
It
will
is
go
taken.
into it?
Everything is taken.
Whatever is there, that your lordship will see whether those discussions are appropriate or not. This is a matter which this court is not going to decide the whole matter on merit. I mean, the
It
suit
can-
itself.
Cannot.
So limited scope. Therefore, my respectful submission. Either way, there is nothing for us to improve it. But if your lordship at all decides that no, we will look into the original record, in that case, I will pray for a stay order. That interim stay should
No,
be there.
not necessary. Next week, he will file his objection. We will finally dispose of the matter.
Next week,
Next.
Oh.
Yes, if lordship so desires, my lord, probably
No, otherwise, if we grant interim stay, the matter will remain pending here for quite a long time.
well, lordship may fix a time.
Therefore,
Even
yes, we will fix
by
a date.
passing an interim order, also lordship can fix a time. We'll be deciding you fine. Meanwhile, this is the situation. Nothing going. Okay. Yes.
let it come after.
Bihur Bond.
After
Bihur Bond, আজি
No, no.
কি তারিখ?
senior counsel.
Before we
So lordship, just immediately after Bihu, lordship can take up. Or, my lord, I have nothing, as I have said, I have already argued in the week. On 10th also, lordship can take up next week. 10th also.
yes, then you
Yes.
file your objection. On that day, we will finally take a call. We will keep the matter as further.
Yes, yes.
For Mr. K.K. Monto, learned senior counsel assisted by Ms. N. Baigong, learned counsel for the petitioner, and Mr. Arzetas, learned counsel for the respondent. Harding Court lays the matter on 10th of April. In the meantime, Mr. Tassel filed his objection.
My lord, the lordship may also specify since the matter was heard at length, both sides.
Yes. Part
Heard. No, that should also go into record.
Yes,
Since
yes.
it is already heard. And no. And even then, the written objection, which will be submitted in the meanwhile, will be as prayed for. He will make a written submission also or objection that may be taken into note of. Otherwise, lordship has heard it.
Yes.
Lordship may
that
just
has been-
specify it so
No,
that
I specify.
yes,
They specify
that will do.
that.
So that thereafter nothing will remain much for us to
Yes,
deliberate.
yes.
Yes. My learned friends, they may also be recorded. by-
Okay, okay. Mr. R. Goswami.
Argusami. Assisted by Argusami and
Assisted by
Mr.
R.
Behel.
Goswami and Ms. Loinso.
Well.
Okay,
Deeply obliged. And it should be reflected in the cause list.
Cause list.
okay. The name of Mr. Goswami shall also be reflected in the call list.
Obliged. Timing item
Deep.
4.
May I please lordship? In this case, petitioner is agreed with the order granting temporary injunction by the appellate court, substituting its view or discretion exercised by the trial court lordship. Now, trial court lordship, suit was filed by the respondent, praying for right title declarations and recovery of possession. May I please take lordship to page 16 lordship, is a part of the plain. Paragraph 3, lordship. That the plaintiff is the owner and possessor of land measuring 1 kata 8 shotaks appertaining to secondary Patta number 102 Dag number 334 of Moja, Talankita Lagpur part 1, Pargona PS Lakhimpur district Kacha specifically described in the schedule below by right of purchase from the defendant. By available consideration of market value of the said land by registered deed number such and such, registered by the deputy registrar Kacha registration Silchar, and since purchase, the plaintiff is in possession of by digging a pond by bamboo fencing since purchase and occupying the same, paying land revenue, etc. Paragraph 3, lordship. The plaintiff, while possessing and enjoying the below schedule mentioned land, intended to construct a dwelling house over the said purchased land by earth filling over the said point to fill up the same from the adjacent National Highway 37 over the said Miadipatta land, that is suit land, executing the appropriate excluding the appropriate cast land of NH 37, but the defendant to
Mr. Professor, you tell me, the land is not in your possession now.
no, this is the dispute lordship. We have sold out land.
So there is also one registered
Between-
sell date.
Yeah, registered land. Between, it is not within the disputed land is not within his purchased land. In between National Highway and his land, there is a pond over the cast land. It is a government land we have been possessing since the time of father. We have excavated a pond and we are using it.
If
Now-
it is a government land, how can you sell it?
No, we have not sold, sir. He is trying to include this government land within his boundary.
Then how this registered sell date was
The registered date
executed?
sell deed is on this, only on Patta land, not on this. Now, he is trying to include this. Now,
Mr. Professor, let notice go at this extent. Then
lordship,
admittedly, there is concurrent finding of both the.
no,
courts,
not
not
concurrent
not
lordship,
in your
not
possession.
concurrent lordship. Trial court dismissed his,
Oh, yes.
tri-
Trial court dismissed.
dismissed. Now, this is my case lordship, that appellate court cannot substitute the discretion applied by the exercise by the trial court. Now, my other friend, the previous case, this case was referred this Wonder versus Antox. That has also been discussed by the appellate court, but it did not follow. In paragraph 60 lordship,
Maybe if the possession is not with you, if the
No, there
balance
is a
of
prima facie case, it is
convenience
not doubt.
cannot be found in your favor.
now there is a prima facie case, there is no doubt. But there is no balance of convenience and injury, irreparable injury. Only prima facie case is not sufficient. This is a settled law lordship. Injury has to be established. And trial court find that there is no balance of convenience because they have not, they could not show that I have constructed, allegation is I have constructed bamboo structure on the pond. And this is the trial court's finding at page lordship page 47, Lordship. They have purchased, so what is the purchase length? There is a prima facie case. Balance of convenience. Page 47. Though the petitioner has averred that the defendant OP has constructed a kacha bamboo fencing dwelling house encroaching the suitland and also started constructing boundary wall in order to dispose the plaintiff from the suitland described in the schedule and further trying to construct another house in the suitland to dispose the plaintiff from the suitland. The petitioner did not submit anything in support of or proof of his contention. That is, therefore, in absence of documents to prove, it is difficult to find out the balance of convenience. Now, on the discussion made above, due to absence of balance of convenience, this point is also decided in negative. Now, if I have constructed a dwelling house, he could have taken submitted a photograph of this. There is a boundary. There is a construction.
Let notice go. Mr. S.D. Professor, learned conflict for the petition. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the judgment and order dated 4/1/2025 passed by the learned civil judge senior division number 1 Kasar in Miss Appeal number 6 of 2023. Mr. be noted here that by the impugned judgment then order dated so and so, the learned civil judge senior division herein of the First Appellate Court has allowed the appeal by setting aside the order dated 17/1/2023 passed by the learned Munsif Lakipur Kasar in this case number 1 of 2020, arising out of title of number 4 of 2020, and thereby granted an interim temporary injunction. Whereas the petition and the documents by some record and also whereas the impugned judgment and order dated 4/1/2025 passed by the learned civil judge senior division, passed by the learned First Appellate Court, and also the order dated 17/1/2023 passed by the learned Munsif Lakipur in this case number 1 of 2020. Let notice be issued to the respondent returnable in 4 weeks. How many respondents are there?
One.
Respondent. Returnable in 4 weeks. The plea taken by registered post with AD and also by the also taken week from today. Interim order. The interim period of the petitioner will be considered on appearance of the other side on next day. List of the 4 weeks.
Published.
Pending item 7. Please, your lord.
The better relates to it is appeal against the order and judgment passed by the learned additional district judge, Shiv Sagar, my lord, declining to grant this divorce, my lord, filed by the husband. Now we have come in the appeal, my lord, against that order, my lord. We pray that the notice may be issued against the.
Heard next of research, learned counsel for the appellant. This appeal under 628 of the Hindu Marriage Act is referred by the is directed against the judgment and decree dated 28/12/2024 passed by the learned additional district judge Chittagong entitled to M number 85 of 2014. It is to be noted here that by the judgment and decree dated so and so, the learned district judge Chittagong has additional district judge Chittagong has dismissed the petition filed by the petitioner. Filed by the appellant herein under section 13 Roman 1 small a and 13 Roman 1 small b of the Hindu Marriage Act 1955. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated 28/12/2024. Admit, issue notice to the respondent. Returnable in 4 weeks, the plea taken by registered post with AD and also by usual process. The SSL call for the record from the learned additional district judge Chittagong. Please the matter of 4 weeks.
Developed.
Item 9.
May I please tell us, this IA has been filed for early hearing. But
So when do you want?
in the months of May or June, my lord, we
May.
can. May first week, lots of work.
Or Mr. Enhoff, learned counsel for the applicant and Mr. Bhakhtiar.
Yes, Lordship.
learned counsel for the respondent, opposite party. This interlocutory application under section 151 of the CPC is prepared by the applicant, struck appellant for early hearing of RSA number 155 of 2020. Accordingly, after hearing learned advocates of both the parties, it is provided that recessal is the matter on
27.
hearing.
Lordship, also LCR has not received.
I'm informed that whether LCR has not been received.
But
That is
office
the problem.
notification 7 January.
It is a case of
notice has
2000
been- Reminder has been issued, but not yet received LCR.
No, today this IA only listed.
I know. I already.
It is submitted at the bar that the LCR has not yet been received. Though the same was called for white order dated reminder dated 7/1/2025. Accordingly, it is provided that recessal issue press reminder to the learned courts below for transmitting the record.
Complex.
Much obliged.
May be, your lordship. This IA is for early hearing, lordship.
Yes,
Deadline
Mr.
was-
Moore.
Date may be,
Date.
date may be fixed.
Lordship,
When?
only I am praying only if possible in the month of April, lordship.
Sorry,
She is out of her own house, lordship.
sorry.
Then lordship, May first week, 6th of May, lordship, it's a Tuesday.
Already a lot of matters have been fixed.
Lordship,
15 May.
lordship.
Heard Miss R. Soduri, learned counsel for the applicant, and also heard some more learned counsel for the respondent. This interlocutory application under section 151 of the Code of Civil Procedure is prepared by the applicant. Excellent hearing.
No,
Oh.
Applicant, lordship, appellant, defendant number 1. I'm the
This
appellant.
petition
lordship.
is,
I am applicant, appellant, lordship.
yes.
Lord.
For early hearing of RSA number 370 of 2017. Taking note of the submission of learned counsel for both the parties, it is provided that recessal is the RSA on 15th of May.
Lordship.
LCR received?
Yes, lordship. Case is ready as regards service and LCR, lordship.
Okay.
Only one IA is pending, lordship, that is IA 750. In that case, already status quo is granted. So interim order may continue. lordship.
My lord,
Okay.
I have a objection regarding that. Kindly peruse the last order.
No, that is first in my RSA, lordship.
My
not in-
lord, that I have
I
the
have- I
problem
have
with the
enclosed.
extension of the interim order.
Last
Kindly
order,
whether there is a prima facie case against a appellant.
No, already interim order granted.
My
yes, lordship.
my lord, kindly peruse the last order.
Last order,
In
I have,
RSA, in RSA.
RSA.
lordship, I have enclosed also with this interlocutory application. Your lordship will find page 39. After that only, we have filed the IA for early hearing, lordship. On 13/2/2025, we sought for an adjournment, lordship. That was not granted, and thereafter, lordship, this order was passed.
The suit property, what the decree was already executed, and I am in possession.
And my status
Thereafter,
quo order is page
They have
29.
filed appeal, and that was dismissed.
Appeal was not dismissed, lordship. The condonation application along with title appeal, that condonation was.
Resultantly, the appeal was dismissed.
Title appeal was dismissed, lordship. So I was dispossessed within
And,
passing of the judgment, 3 months within the passing of the judgment, lordship. 750. I have enclosed the order, lordship. Page 29, your lordship will find. Objection filed with 750. Objection filed with 750. I put up to 750. Online, my.
Mr. Moore, let the interim order be there till final hearing.
My lord, I am not able to enjoy the property which is owned by us. In the guise of status quo, I am not able to construct anything. I cannot use the
No,
property.
since we have already fixed the date, let it be there till that day.
My lord, my children are there.
Unless
I'm
you
not
file
able
any
to.
objection, Mr. Moore,
My lord,
unless you file any objection in this application or any prayer for vacation of this interim order.
I have already filed
When?
objection
When?
in the IA the injunction application. I have already filed 750. Filed on the 5th May 2021.
Order was granted on 19/3/2021. Thereafter, 750 IA was not heard, Lordship. Only interim was continued and it was already listed in for final disposal, Lordship. Till final disposal, the
On account of
respondent
the
shall-
last order, I am started to construct a premise of construction over there. In view of the order passed by this honorable court in the RSC. Because for the property which I am in my possession, I am not able to use the property.
So we will finally take a call on next day. Let it be there till then.
My lord, your lordship may observe that I may construct the premises, and if she win, she will get the property. That may be recorded.
Pardon?
I may permitted to construct the premise in the houses there. If she will win in the appeal, then the property will. She will get the property with the constructed premises. Whichever I will construct.
That means he wants to construct the house for me, Lordship.
For me or
in
with
the event that I will get the suit property, Lordship, then I will get the structures.
With my property since 2017.
And we are claiming our share over that property, Lordship. Substantial question
Share,
of law was
my lord,
formulated
then,
only on that, Lordship.
Kindly peruse the written statement filed by her.
No. Not that.
She has stated that the property was gifted by the.
On the day of hearing the matter. Not today.
That interim was continued later on also, Lordship. And
In view of the last order, I have started to
and
construct.
thereafter, Lordship, after filing of his objection in the month of May, in the month of September, again it was continued, Lordship.
Okay. Mr. Moore till 15th of May. Let it be. Wait for 15th of May.
That order may be passed in IS 750, Lordship.
Okay.
Your
Interim
Lordship will
order
file-
passed in
in
IA
IS 750 on 24/9, interim was
continue till 15th of May.
Lordship.
Item 11.
Obliged, Lordship.
Yeah, please, Your Lordship. This is a condonation of delay petitioner.
Pardon? Condonation order. Pardon?
51 days of, or 52 days of delay.
50?
52.
52 days. Take down a hard mister.
S. Pegu.
S.
S. Pegu.
Learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act 1963 is referred by the applicant for confirmation or delay of 52 days. Preparing accompanying appeal, connected appeal. against the judgment and order dated 25/10/2024 passed by the learned member MSc Bhuguri in MSc case number 328 of 2009. Let notice be issued to the respondent. When the judgment was passed by the tribunal? 24.
25/10/24.
Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with ADN, also by legal process within a week from today. Place the matter after 4 weeks.
Obliged.
Maybe your lordship. Lordship, I ask for condonation of delay. 3 days, lordship.
3 days.
Lordship. I'm
Let
appearing on
notice
behalf
to-
of T. Kolita, lordship.
Third, Mr.
R. Sharma, lordship.
R.
Sharma.
Learned counsel for the applicant. This interlocutor application under section 5 of the Litigation Act 1963. Read section 173 of the MPA is preferred by the applicant. For condonation of delay of 3 days in filing MSc appeal, connected MSc appeal against the judgment and order dated 18/10/2024 passed by the learned member MSc Development case number 279. Let notice be issued to the respondent return for which the be taken by registered post with ADN of the legal process.
My lordship.
May you please, your lordship, there is a 61 days delay in this case.
Pardon?
61 days delay.
60?
61.
1. Are you sure 61?
Yes, your lordship.
Okay.
May I please, your lordship?
Yes.
But this IA application is filed for 113 days delay against the order dated 27/5/2024 in connection with title suit number 310 of the 2012.
Heard, Mr.
SD Roy, your lordship.
As the Royal Learned Counsel for the applicant, this interlocutory application is referred by 2 applicants for condonation of delay of 5 days in filing.
Lordship, 113 days.
Okay, a condonation of delay of 113 days in filing connected. Revision petition against the order dated 27/5/2024 in title suit number 310 of 2023 passed by the learned civil judge Junior Division Nagaon. Let notice be issued to the respondents returnable in for which they be taken by registered post with ADN to the legal process or return today.
My lord,
Please number for which.
my lord, I have an interim prayer also in my petition.
No, let the appeal be admitted first, only then we will consider the interim.
That case is pending before the.
No.
Much of it.
My previous lordship, my lord. Now at this stage, notice may go, my lord. There is a delay of about 2,821 days.
3,000?
32 days. 2,832 days.
You have mentioned it as a 2,832 days.
Yes.
Is it?
2,832 days delay. As per the registry, my lord.
And as per you, it is more than 3,000. Heard Mr. Professor Learned Counsel for the applicant. This interlocutory application under section 5 of the Litigation Act 1963 is deferred by the applicant for condonation of delay of 2,832 days in preparing a connected RSA against the judgment and decree dated 21/9/2015 passed by the learned counsel number 1 entitled to number 42 of 2012. And also against the judgment and decree dated 18/3/2017 passed by the learned civil judge senior division Morigaon in title appeal number 25 of 2016.
It's a reverse judgment, madam.
Agor to a judgment and decree 20. So, and let notice be issued to the respondents returnable in 4 weeks. They be taken by registered post with AD and also the result process.
13. Madam, with next week I will take statement.
Please, Your Honor.
You have not gone through the record.
Actually, Your Honor, it was, there was an defect and then I did not correct it in the office copy, Your Honor.
Heart means your good name.
Refika Dada.
Learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 65 days in preparing. An appeal against judgment and order dated 6/11/2024 passed by the Commissioner for Employees Compensation for beta in EC case number 109 of 2024. Let notice be issued to the respondents returnable in 4 weeks. They be taken by registered post with AD and also by the process returnable from today.
17.
Here in this case, I am praying for the deposition and release of 50% of the awarded. Lordship, though the appeal was admitted, but no order has been passed for deposition or release of the of any amount. Lordship.
Your Lordship, we will be filing an objection against the AIA, Your Lordship.
Claimant,
There is no stay.
there is no stay. Prayer is there, but there is no stay. Lordship, claimant is suffering a 4% visible vendor. Lordship suffered 40% disability and 50% functional disability, loss of earning as considered by the Learned Tribunal. Accident occurred in the year 2017, but till that he has not received any amount. At least 50% may be released.
Heard Mr. M. Talukdar, learned counsel for the applicant, and also heard Ms. Lorenzo, learned counsel for the respondent. This interlocutory application is prepared by the applicant for directing the appellant United India Insurance Company Limited to deposit 50% of the awarded amount by the learned member motor accident of the Pasar at Silson. The learned counsel for the respondent opposite party submits that the respondent opposite party will file objection. That's for granting her sometime. There is allow basically the method. When?
Date may be fixed.
Sorted.
19.
Nine.
19.